We are live on the record and court is in session.
Thank you. So good afternoon. Calling the case 2021 J5, Diplomat Property Manager versus Crystal HIMES and another. I'm Justice Massing of the Appeals Court, and so this is a hearing on the defendant's petition for relief from the bond. And while we don't follow the, I'm not going to follow a strict 15-minute time, and but I would like to hear one attorney at a time, and I'll start with the appellant. And there's a couple of, I received a barrage of papers today. We have and so I think I actually, Patricia, if you could unmute Attorney Kingston, I want to put a little discussion of the papers. There's a few motions pending. There's one that was filed on the 15th. The first one that was filed was a request for a stay from Attorney Wasser, and I take it that was mooted by Judge Winnick's decision on the 15th, saying I'm basically not going to look at this anymore.
In part, yes. I wasn't sure what the court was doing or was going to do with the petition for the affidavit for indigency, but that's really a separate matter. As you read from our notice of appeal, my only concern was that we seemed like we were being deprived of that procedural that mechanism. I cited to the appeals court case that that says that you have to wait, you have to see what the appeal bond is if you're going to claim that your indigency was caused by the appeal bond itself. That's the subsection C.
Before I get to that, just on that, you're no longer seeking a stay of this. Okay, so let's move to the next one. The next one is you filed an affidavit of indigency in the housing court. It apparently was not looked at because of the action that Judge Winnick took. But so you would like to refile that here, and there's an opposition to that from the plaintiffs. So
I guess the only relief I don't want to tie this court's hands to basically fix this matter procedurally if that's the most expedient thing to do, but I just don't. My concern was at what point do we either get the lower court to rule on indigency, because this court's supposed to be reviewing what the lower court did. So I don't know if they need an order from this court or from Your Honor to tell them that they still need to at least, the clerk's office is supposed to determine whether or not they're make an indigency determination. And so, that was sort of the limited nature of the appeal. It wasn't so much to decide for this court to review whether or not there's indigency, but rather to make sure that we're getting that opportunity, because, under the indigency statute, just generically, you can bring that at any time in any court proceeding at any stage, including supplements there too.
Well, it looked to me that the judge had pretty much closed his mind on that. But let me hear from Attorney Kingston. What in terms of sending it back to the housing court to consider it again? What's your position on that?
This is an issue we addressed pretty thoroughly in that opposition we filed today, and I apologize that it had to be filed today, but we were responding to two motions at the same time. Essentially, the petitioners had every opportunity to timely file this. They missed the deadline, which was October 30th. It's 10 days to file a motion to waive bond. They missed that, but there were plentiful opportunities for them to put this before Judge Winnick. The appeal bond order wasn't issued until December 28th. And so we had, I think, 69 days between the entry of judgment and that order, never filed an affidavit of indigency, motion to waive bond. Even after the appeal bond order was issued, for the first time on January 4th, they filed the affidavit. That was going to be heard in the Central Housing Court on January 14th, before this appeal was entered or the record was transmitted to this court for appeal. And petitioners withdrew that motion. So Judge Winnick just never had the opportunity to review it. That's why it's not on appeal. It's not because he refused to consider it or there's some procedural mistake. So the reason we set forth in our papers is under the appeal bond statute, chapter 239, section 5, the only thing that gets transmitted to the court are the findings and the order of the lower court in anything relevant to the appeal. And because our position is that the motion to waive bond and affidavit are outside of what's reviewable by this court, they're simply not relevant. And so we don't think that these papers form any part of this appeal because the petitioners failed to put this before the Central Housing Court. They had the opportunity and they simply, for whatever reason, they withdrew those papers.
I understand it. So let me go back to Attorney Wasserman, and let me just put it to you. with a little bit additional questions. So there's a judgment issues on October 20th. Timely motion to reconsider on October 28th. That's denied on November 20th. You file notice of appeal from that timely again on the 25th. Seems to be no problem there. That is not accompanied with a motion to waive the bond, but rather the plaintiffs then on December 1st file a motion to set the bond. You oppose that in December 8th, and in the papers anyway, there's no mention of indigency. It's a lot of procedural reasons why there shouldn't be a bond, but not a mention of indigency. Apparently, you did raise it during the hearing, and in Judge Winnick's decision setting the bond, he says that he gave you an opportunity to establish that, and you didn't take it. So I think your argument in part to that is the chicken and the egg thing. I don't know what the bond is, so how do I know if I'm indigent yet? So maybe you can address that whole procedural.
Yeah. So the first thing I want to just clarify here, we're for me anyway, I think this is conceptually two different things. One is the indigency question, and then whether you get relief from bond based on indigency. And then the second thing, which what my sister was alluding to, the motion that was refiled and then denied, that had to do more of the Damascus case, the constitutional question of, regardless of indigency, whether the amount of the bond, even if you could manage to pay for it, is essentially a de facto denial of your appeal, and therefore allows meritorious appeals only for the wealthiest litigants. And so these are two separate matters as I see them. And when we withdrew and then refiled that motion, what was still on the docket was the affidavit of indigency, is a separate matter. Now, what Judge Winnick had said to us, this is an order he basically made from the bench, was that if you didn't bring it now, you can't bring it later. I'm not going to revisit this. And so I did not interpret his order about the later filing affidavits about costs and carrying costs of the property and who's paying for what. I didn't read that as an invitation to then also file an affidavit of indigency or anything financials having to do with my clients. In fact, he specifically said that he would not allow us to do that. And I asked him if he would put that as part of his written order, and he declined to do that. But so I didn't want to violate, the orders of a court and get myself into trouble. So, this is again, due process. We have to be clear on what people's rights are, what's expected of us, what the process is. But what I did do is we filed that affidavit of indigency when it was ready, when my clients had due process notice of what the appeal bond was, when they could actually file an affidavit. This is the U.S. Bank Trust versus Johnson matter that this court decided, 96 Mass App 291. That you're filing an affidavit saying that you can't pay for the appeal bond and pay for necessaries, and you wouldn't be able to do that unless you know what the appeal bond is. So that's that's not indigency as an issue has yet to be decided by the lower court or by the clerk's office. And so what I really just have before Your Honor, if you can help us with this, and certainly I don't want to tie our hands by waiving any of these rights, but just I believe that that's how the process probably should be, is that the clerk's office should be determined whether, based on the face of the affidavit, that my clients are in fact indigent because of the appeal bond. That could change, however, because we're here today now also to talk about what was ordered as the appeal bond, and Your Honor could reduce that amount or get rid of it altogether, and then that issue would be moot. Because again, the claim for indigency is only based on the appeal bond order itself. That's what's causing the indigency.
So, but isn't the purpose of 239 Section 5 to permit, is to avoid the constitutional problem you're talking about? The statute says if you can't afford to pay the bond, you should ask the court to relieve you from the obligation to do it. And you didn't until months later.
That's right. And so, this is a little snafu we have in the laws. The law's written one way, and then the courts have to interpret it another way to keep it, constitutionally sound. Historically, that provision has been applied to, a traditional landlord-tenant case. And then when we had these other grounds to bring these in, so if my clients were indigent because they were just all the indigent, regardless of the appeal bond, going into court, they were, indigent or poor or what have you. If they got services like mass health and things like that, would automatically make them indigent. So there's like a subsection A, there's a subsection B. If you know going into court that you're already indigent, then yes, then that's when you would raise that to the court. However, if you're fall under subsection C, this is the Johnson case that this court decided. The court recognizes, I've argued this well before Johnson, I've been saying this in my papers, that how can I have my clients file an affidavit claiming they're indigent when they don't even, based on the appeal bond, that is, when they don't know what that amount of money is. As you said, you're under the chicken and egg issue. So this is, in order to make it a workable system, you have to allow the litigants to know what the appeal bond is first. And as I indicated in my papers, which Your Honor can read my motions, there are other cases that I've had where courts don't even do a regular monthly payment. They'll just do a flat fee. They'll just say, pay $7,500. And I cited that case. There's another case where I think it was like 6 months. They had them pay 6 months worth of what a market rent was. So, you never know what a court's going to do. And there's no way for my clients to certainly wouldn't have anticipated both a huge lump sum and a monthly. That I wouldn't have anticipated.
Well, and you've got a money judgment right as of October 20th for 67 or 74 or whatever it is. I mean, couldn't you reasonably anticipate what the bond was going to be and what the use and occupancy was going to be?
No, and the reason is that because typically, first of all, in this case, definitely not, because we're not even sure the appeal bond applies at all, because these parties don't fit the definition of under Section 5 or Section 6, and that actually goes to standing and jurisdiction as well. But the other, just as a matter of math, typically we don't. If the court's going to apply an amount that's so great, then you fall into the Damascus issue, and that's what I was cautioning the court, saying, and look, if we're going to apply this thing, I mean, I don't know exactly what my clients' finances are from day to day, but they had in this case, or in these cases, there are 6 lawsuits going on, but they had previously done filed for indigency status, and that went up to this court, and the court granted some relief in that regard. So, I mean, the idea that the average litigant going into court can somehow come up with $77,000 and really $2,400 of that in 4 days, and then the remaining in 10 days, it's just not realistic. And so, I did raise that to the court's attention, saying, look, at least, again, having nothing to do with indigency, we should keep it so it's at least we know it's affordable. We've got these poor litigants of mine, my clients are paying for 2 attorneys and 2 duplicate lawsuits that are pending at the same time, plus appeals. Multiple appeals are all happening at the same time. I mean, they're wiped out. And so, I was asking the court to assign a reasonable balance and just award $1,000 a month, hoping that would, at least satisfy the Damascus test.
All right. Is the Johnson case, is that a published decision?
Yes, Your Honor. That's 2019 96 Mass App 291.
Thanks. And what's the site for the Damascus case as well?
Damascus is Damascus versus Board of Appeal 359 Mass 55.
Okay. So I'm going to turn it in a minute. I'm going to turn it over to Attorney Kingston to respond to all of this. I'm sorry. Is there anything else you'd like to put before me, though?
Well, I guess if we're ready to get into the nitty gritty, I would just really briefly touch upon why I'm saying that the appeal bond doesn't apply at all in this case, which we're looking at. Do you want me to get into that right now, Your Honor?
Yeah.
Okay. So under 239 sections 5 and section 6, it defines under what limited conditions an appeal bond is awarded or is ordered. And so under section 6, because we have a foreclosure kind of a scenario here, sort of, there was a foreclosure. If the action is for possession after a foreclosure, section 6 says the condition of the bond is for entry of the action and payment to the plaintiff an amount of rent from the day when the mortgage was foreclosed until possession is recovered. So by its terms, Section 6 is contemplating that this is a foreclosure deed purchaser, that's who the plaintiff is. And that's where it's getting standing in foreclosure to even bring a summary process case in the first place, which is 239 Section 1. That's the jurisdictional limitations of who can even bring summary process. So what happened below, and you can read from the judge's order, they went to the next scenario under Section 6, which is if the action is for possession of land after purchase. I'm not sure how well Your Honor is familiar with the story here, but there was an insurance company that was subrogated to the rights of a mortgagee. That was the first lawsuit. It was settled completely. We have a four corners of a settlement release agreement. That should have been the end of all of these disputes. And it contains an indemnification clause, a duty to defend, all of that. And that's what's pending in the prior pending plenary action in the Superior Court.
Is that not with respect to the second mortgage, though?
No, see, that's where all this confusion comes in. But they keep changing their story. But the original lawsuit that they brought was for a deficiency action on the first note of the first mortgage. And then in the process of us battling that out for about, I don't know, 8 months, 9 months, they changed the story. This has been going on even before that lawsuit was filed. We've been dealing with them for probably 4 years, and they've changed their story. They've said everything under the sun you can imagine. It's been crazy, including that the first mortgage was paid off, and therefore my clients couldn't even get a loan modification. I mean, and that's the craziness for us, is like, either they should keep their home because they were wrongfully denied a loan mod and they should get that, or they should keep their home because they have this settlement and release agreement with a sophisticated entity that warranted that it had this right to bring these claims and to make the settlement. Again, we're talking about jurisdiction. That's also outside the jurisdiction of the housing court. It wasn't part of the complaint. They're not necessary parties that were made, joined in this action. But again, just getting back to what the judge's decision, when he latched on to the portion of Section 6 that says an action after a purchase, that section also relates back to 239 Section 1. When they talk about where a purchaser holds over, that would be a case where Diplomat is bringing an action against, in this case, it's PNMAC. PNMAC Mortgage sold them that title. They didn't, and they didn't even have the foreclosure deed. This was like multiple transfers down the line. When PNMAC sells Diplomat the title, that's the relationship where there's privity of contract, but they're not the defendant. My clients are, and there's no privity of contract for my client. So this portion, they're saying that they get a bond for under Section 6. When they talks about, it relates to it when they talk about a purchase. Well, not at the time of the foreclosure, but long after. That's just an ordinary purchase, and that relates to a privity with the actual purchaser. So that would have been between Diplomat and PNMAC, not the Lozanos. There's no privity. There's no relationship at all between Diplomat and the Lozanos. The Lozanos never held under PennyMax or PNMMax, whoever that is, PNMAC mortgages. They never held under their purported title. They held under their original grant of a deed, of a title, and they held under, at best, UGRIC's rights as the mortgagee of the first mortgage. That's where this thing gets a little sloppy. But this is why I'm saying Diplomat doesn't even have jurisdiction or standing in this case, because that's men's conveyances. I cited to the Warren versus James case.
No standing in this case, or no standing with respect to the bond?
Well, it's both, because in the summary process statute, they're always looking at privity between the parties. It's transactional. It's like an event that just happened, or there's a contract involved. So between landlord and tenant, the privity is the lease agreement. Between a purchaser and a buyer, the privity is the purchase and sale agreement. With a foreclosure, or the mortgagor and a mortgagee, or the foreclosure deed holder, the privity is the mortgage, and specifically the power of sale that gives the mortgagee the right to sell it either to itself or to a third party. And that's where it ends. And so that's where
if the appeal goes forward, these are the arguments you'll be making on appeal.
That's correct, Your Honor, but that's correct. However, when it comes to questions of jurisdiction, and Your Honor can make this decision based on the Section 6 aspect, but it's every judge and every court's obligation when the issue of jurisdiction comes up to address it. And so I don't know if Your Honor wants to, again, this gets procedural issues. I don't know if Your Honor wants to address it here in a single justice appeal, refer that to the panel. I don't know, but we do have this cloud of a jurisdictional question hanging over this case.
Okay, understood. So that's your first salvo. And then what's the next line of attack?
So, well, then the next thing is just if you're deciding, I'll get off jurisdiction for the time being, and let's just take a look at what Your Honor would apply as a reasonable bond. And in the recent case of Bank of New York Mellon versus King, 485 Mass 37, specifically at page 51, the SJC sets forth non-exhaustive lists, but certain factors for a court to consider in posting a bond. And among those factors is the fair rental value of the property, which we have here is roughly $2,400 a month. The merits of the defense. I mean, I don't want to get into that too lengthy, but in this underlying case, Diplomat wasn't even required to prove a chain of valid title. They didn't even satisfy the Ibanez-Larrace test. We have the prior release and discharge because of UGRIC's that four corners of the contract, which this court doesn't even have jurisdiction to decide, the housing court, that is. We have lack of jurisdiction, as I said, over the prior release contract, lack of jurisdiction because of 231 section 1, lack of jurisdiction or avoid judgment because of rule 12b9, where the superior court already had jurisdiction over this case. It's a prior pending action where Diplomat filed a counterclaim even in that case. I mean, we did it in the main claim, we challenged the title, but also they filed a counterclaim seeking possession and use and occupancy, a duplicate case that's pending here. And then we have rule 19.
I read King earlier this month. I haven't read it in the last few days, but so you're saying that it says that in terms of the amount of the bond, I mean, I know you've got to have a meritorious issue. But so you're saying also in terms of the amount of the bond, King says you can take into account like the likelihood of success?
Not the likelihood of success. I think it's more just trying to establish non-frivolous or a meritorious claim. I mean, the standard was always non-frivolous. It's a little unclear whether
Are you saying that also applies to the actual dollar amount of the bond and use and occupancy? No.
It's among the factor. Yeah, that's a good question. But when you read that section of the case, it just says it's listing the factors that a court should consider when deciding either whether to apply a bond or the amount. And so the factors were fair rental value of property, merits of the defense, the amount owed per month on the mortgage, which in this case, there is no mortgage, the number of months that normally has been paid on the mortgage, which in this case, there is no mortgage, the real estate taxes on the property. I mean, they're up to current. Different parties are paying different amounts of the house, but some of the troubles my clients have gotten into in more recent times is what's being registered with all the taxing authority, so that the bills are now going to them instead of my clients. But my clients paid the bills when they had access to them, and they've continued. They paid the condo fees up until just like a month or two ago. Another factor is the expected duration of the litigation. Here, it's a little bit of an unknown because we have Diplomats sort of placing the cart before the horse here. They're interfering with the prior pending action against parties like Diplomat, like the insurance company, UGRIC, parties with prior and superior rights to Diplomat. And, maybe that requires a stay of this action until we can get to those, because had this case all been heard in the fourth lawsuit in the Superior Court with the plenary action with multiple parties, they would be deciding the rights that came first and are superior to Diplomats. In other words, if my clients prevail against UGRIC, Diplomats out. They're out of the picture. They have no position. If they prevail against Christiana Trust. I'm
probably not going to get into that level of detail in deciding the bond motion. So I think I understand. I think I understand your position. And part of the thing is that if I'm not going to send it back to the housing court, then I would need to look at the affidavit of indigency. So
I mean, We do have an affidavit, Your Honor, in the packet itself that you have, but it's just it's more brief. It's just my client saying that they have $3,000 in their bank account. Yeah, and that they, even if they could qualify for a loan, they'd never be able to do it within the 10 days. And again, this gets more into the Damascus parameters, and we're just trying to make it affordable.
But I think I understand your arguments. Let me hear from Attorney Kingston.
Thank you, Your Honor.
Thank you, Your Honor. I just want to first address the indigency issue. U.S. Bank v. Johnson, the 2019 appeals court case, in that case, the defendants had not met the 10-day deadline to file a motion to waive bond. But they did file it before the housing court ruled on or set the bond. And in that case, the housing court said, well, you didn't meet the 10-day deadline. That's jurisdictional. I can't even consider this motion to waive bond with your affidavit. So that went up to appeal in this court, and this court held it's a deadline under Chapter 239, Section 5e, but it's not jurisdictional. So it doesn't deprive the court of jurisdiction to hear a late filed motion. We don't dispute that. That's the law of the land. But the court in dicta said, obviously this wasn't applicable to what happened in Johnson, but in dicta notes, in some cases, it might be appropriate that you file it after the bond is set, because in some cases, you might not know what the bond is until that time and whether you'd be indigent. But the court noted there have to be some reasonable parameters. And so really this is about discretion of the trial court in deciding whether to rule on an untimely motion to waive bond. Having said that, that's not what happened here. After the housing court issued its bond order on December 28th, the defendants had 6 days to file their petition for review, which they did on January 4th. At the same time, they also filed a motion that included, it was a request to waive the bond on the basis of indigency. They filed that on January 4th, and then they filed the affidavit of indigency. That was the motion, along with the affidavit, that was scheduled for hearing before the housing court on January 14th. This was going to be heard by the housing court. This is not a situation in which the housing court said, that's untimely, I'm refusing to consider it, which I still think would be a discretionary decision. That's correct, but that's not what happened. After that's scheduled for hearing on January 14th, the defendants voluntarily withdraw the motion to waive bond. And the only reason the affidavit is on the record is in relation to that motion. You can't just file an affidavit of indigency. You also have to file a request to waive bond under the statute. You have to file both of those together, and it's the defendant's burden to show indigency plus non-frivolous argument on appeal. So this was going to be heard by the housing court. None of us can sit here and say what he would have done with it, whether he would have said it's untimely, whether he would have ruled on the merits. He wasn't given that chance. The motion was withdrawn. So that's why it's never heard in the housing court. It wasn't that the housing court said, you're barred from filing this, I won't hear this. He filed it, it was scheduled for hearing, and the record speaks to that. So I disagree with my brother. My brother's recitation of what happened below is simply not accurate. And if Your Honor looks at the record, it's clear this was going to be heard and then was withdrawn for, I submit, strategic reasons. So it's only after the record's transmitted to the appeal that the defendants tried to refile it in the housing court. And Judge Winnick at that time rightfully says, I can't consider this. This is pending on appeal. So he had his chance, he waived it. And to say now that this court either can consider it outright on the merits or should remand to the housing court, that's really a distortion of what happened here. He could have been heard. We had a hearing scheduled to be heard and he withdrew it. So that's just the first thing I'd say, Your Honor. I don't think there's any procedural error here. I think this was a strategic manipulation of the proceedings below, and they've simply waived the right to be heard on the indigency issue. Regarding the bond amount, I know my brother makes an argument that there needs to be privity between the plaintiff and the defendant in a summary process case. It's simply not true. The statute tells us who can bring a summary process case, Chapter 239, Section 1. There's two instances that apply here. One is after foreclosure, and the second one is a purchase of property. And the Lozanos continue to hold over. So either of those scenarios apply here. Judge Winnick actually addresses this at some length in his appeal bond order. It was an argument that was already rejected. The defendants had filed a motion to dismiss for lack of jurisdiction. Judge Horan denied that motion, but then Judge Winnick just decides in the context of appeal bond to readdress that issue at length in his order. But it just simply put, the statutes, Chapter 239, Section 1 tells us that Diplomat can bring this case because it purchased the property after foreclosure. And Chapter 239, Section 6 tells us that Diplomat's entitled to a bond in this scenario. So to me, the only real issue here is the reasonableness of this bond. And I've heard my brother concede that the fair rental value is $2,400. That is the undisputed evidence. So the question is this the amount of the bond reasonable? Chapter 239, Section 6 allows a bond reasonable amount as rent plus cost. Judge Winnick ordered reasonable amount as rent. He didn't include costs. In fact, he discounted $7,050 paid by the Lozanos. And so he could have ordered a significant amount more than what he did. It's well within what the statute allows. So I really don't see how this is an unreasonable amount. My brother mentions Bank of New York Mellon v. King and certain factors that the court may apply. That's a case that involves a waiver of a bond. And so those factors were applied only to the periodic payments that apply where the bond has been waived under Section 5E. So I don't think, it's my position that those factors don't apply to the amount of a bond under Chapter 239, Section 6, where it's not been waived. Even if those did apply, if the court looks at kind of all of the equitable discretionary factors here, the defendants, this was a November 2016 foreclosure. They have not paid their mortgage payments since 2011. That's 10 years ago. They're not paying the carrying costs. And I know, there's an argument that they're not paying it because the bills are being sent to us. That might be true, but the bottom line is they're not paying the carrying costs. We're paying water, sewer, HOA, taxes, forced place insurance. And so if we do look at those discretionary factors, I think it more than supports this bond order that Judge Winnick issued. And just procedurally, there was a pretty lengthy hearing held before Judge Winnick. He issues this 10-page order. He carefully sets out what he's finding and why. Procedurally, this was done by the book to a T. There's no error here. And so I think that the only argument that my brother might have is he wishes that Judge Winnick would have come out a little differently. That's a discretionary decision. There's really no error in what happened here. So I think I've outlined a lot of those issues in my papers. So I'm comfortable relying on them for the rest of the arguments, unless Your Honor has any specific questions.
On how King applies, can a judge right cut down the bond as for indigency or right under. If a defendant hasn't met their burden to show waiver on agency basis, I think your question is, can a judge consider affordability? Well, is waiver an all or nothing proposition? Can it be like partial waiver?
So no, the only way you can get a waiver of the bond is if you satisfy under Section 5E. Can the court consider, affordability of the payments? I think I don't think we have a case saying that it can. But, I also don't think that's really a relevant factor here because the defendants never really submitted any evidence that this bond would have been unaffordable to them or these payments would have been unaffordable. But I also would say, when we look at an amount of the bond, the reasons why we see higher bonds is because of the length of time that the defendants have occupied a property and the value. And so I don't think affordability should be, if you're going to occupy a property that's worth $2,400 per month for 34 months, then you're going to have to pay that amount. And so I don't think we should be looking at affordability because they've occupied it and that costs money and that's real money that should be paid.
And okay. I think I understand, and I do have your papers. I know there's a motion to strike those papers, but I'm not. Rather than that, I'm going to give Attorney Wassers, some time to file a response if you'd like to.
Thank you, Your Honor. Your Honor, can I clarify just a couple of points? We'll be very brief. You may have answered me. Why did you withdraw the January 4th motion? That was entirely a scheduling conflict issue. I had so many things going on, including arguing an appeal, COVID, family things. There was a lot going on, and normally you can do that just with the clerk's office, but in this case, they weren't allowing us to do that. And so just to make things simpler, I got past the date in which I had my appeal and everything else that was happening in my life and other cases. And then I just refiled it. But what's really important to note there is if you read the notice of withdrawal of the motion, as I said in the beginning, this is separate. There's two separate things. There's the Damascus constitutional question, and then there's the indigency question. What I withdrew and then refiled, and I specified in the withdrawal, docket number 103. That was the motion to set aside the appeal bond based on this Damascus standard, not having anything to do with indigency. So that's just a slight inaccuracy. And by the way, to answer your question, Your Honor, about what the court is allowed to do in terms of adjusting the amount of the bond, that's covered under subsection F of 239 section 5, and it includes amending, rescinding the amount of the bond, findings, anything. I mean, you have free reign. It's as if you're, again, the standard is if you were initially deciding the matter for the first time. So you do have wide discretion to do anything you want with the amount of the bond.
I just so I'm not sure what I'm going to do, but just so I can have all the information for you, I would like you to submit the affidavit, which was submitted in the housing courts. It's not like something that's not on the record. I understand they might not have considered it, but I just so I can have everything in front of me. And I also would like you to send me include a copy of your motion to withdraw, which is not in the assembly, and it's not even available online with the trial court docket. So I haven't been able to see that. Okay. It's characterized by Judge Winnick in his motion saying that he's not gonna hear it in his order. And you can, if you'd like to file a response to the papers that were filed today, how much time do you need?
Probably about 2 weeks, Your Honor.
Can you do it by a week from Friday?
I will try, yes, Your Honor.
Okay, thanks. So week from Friday, get your opposition, that copy of the motion withdraw and the affidavit. And with this great rule in the appeals court, 15 minutes per side, no rebuttal. And it's a wonderful thing because it prevents all the back and forth. But let me see if Attorney Kingston has anything else she'd like to add.
I would just briefly on the withdrawal, when the court sees the motion that was withdrawn, it was a request to waive bond. And so the only reason that the record was transmitted to the court after that is because there were no pending matters in the housing court. With regard to a scheduling conflict, my brother had informed the housing court while he didn't have a technical conflict, he would have preferred a different hearing date. And so the housing court instructed him to file a motion to continue the hearing date, which we would have assented to. He just simply chose not to do that, and he withdrew the motion. There's nothing in terms of like impossibility of being able to be heard on this. So I just want to make sure the record's clear on that, Your Honor.
Clear and recorded and archived. So, all right. So I'm gonna take this under advisement. I'm gonna get additional submission by next Friday, and I'll try and respond very promptly after that.
Thank you, Your Honor.
Thank you both. Court is in recess.